regulations and the rapidly evolving technological. To begin our proceedings and the international seminar, let let us all take a moment. We invite you to listen and join in the singing of the national anthem of
Selesai
Indonesia.
juga. Ini ya hal baik apa yang bisa
Okay, to begin our international webinar, to begin our proceedings with honor and patriotism, let us all take a moment. We invite you to listen and to join in the singing of national anthem of Indonesia, Indonesia Raya. Please, operator.
Bangunan ruang baru.
Okay, thank you, our operator. Well, thank you. Moving forward, we would like to invite the Rector of Universitas Dirgantara Marsekal Suryadharma to deliver the opening remarks. Please welcome Marsekal Muda Punawirawan FH Marshal Red Dr. Sungkono S.A. M.Si. The floor is yours, sir.
Okay, thank you very much, Dr. Rizky. Assalamualaikum warahmatullahi wabarakatuh. Peace be upon you and warm greeting to everyone. The Honorable Air Vice Marshal Retired Dr. Sujono SHMH, C.F.R.A, Dean of Faculty of Law Unsurya, all Vice Rektor Unsurya, distinguished speaker Dr. Jinyoung Choi from the National Institute of Air and Space Law, Leiden University, Ridha Aditya Nugraha, LL.M from Universitas Prasetiya Mulya, and Dr. Supriyabu SHMH, Lecturer, Faculty of Law Unsurya. The Honorable Dean of the Faculty of Prasetiya Mulya, Vice Dean of the Faculty of the the Vice Dean of the Faculty of LL Unsurya, all lecturer and student, moderator estimate organization committee and Civitas Academica Unsurya, and unforgettable all international webinar participants from various countries. Praise be to Allah Subhanahu wa Ta'ala, the Almighty God, who has given us the health, strength, time, and opportunity to hold this international webinar hosted by the Faculty of Law and Good Health. But the theme, the future of the air law Indonesian and international perspectives on air and space law. This webinar discussion aims to first analyze the impact of digital transformation on aviation safety and liability. Second, explore the legal implication of suborbital flight and the transition from air to space. And third, address the urgency of environmental sustainability in aviation, green aviation. Fourth, strengthen Indonesia's position in international forum regarding aerospace sovereignty and commercial space law. Distinguished guests, ladies and gentlemen, the era of technological transformation, public safety, and global policy dynamic demand that we not only keep up with the development, but also establish a legal framework based on the principle of justice, accountability, and sustainability. On the other hand, the landscape of global transportation and technology is undergoing a paradigm shift as the boundaries between traditional aviation and outer space activities becoming increasingly blurred. The legal framework governing this domain must evolve. The rapid advancement of aerospace technology, the emergence of private space exploration, and the increasing density of global air traffic necessitate a robust revolution of current legal doctrines. In the international arena, air law and space law are no longer isolated disciplines. Issues such as carbon emission regulation, the integration of unmanned aircraft system into civil airspace, and the commercialization of low Earth orbit present unprecedented challenges to the Chicago Convention and the Outer Space Treaty. As global power and private entities rise toward lunar mission and satellites mega constellation. International cooperation, the standardized legal norms are vital to ensure safety, security, and sustainability. Ladies and gentlemen, regulatory reformation and governance. The global aviation and aerospace landscape is undergoing a period of unprecedented transition. As technology advances and the sky become increasingly crowded with commercial, private, and unmanned flight, the legal frameworks governing this attitude face new challenges. The future of air law demand rigorous harmonization between Indonesia national regulation and international convention to ensure safety, security, and legal certainty in the third dimension. As an assimilating nation situated strategic crossroad, Indonesia holds significant stake in the future of airspace law. With the development of the National Space Act, I say again, with the development of National Space Act, the ambition to host a domestic spaceport, Indonesia is transitioning from the mere observer to the active participant in the space economy. In this regard, in this pertinent of, I say again, this regard, it is pertinent to knowledge. The Indonesia has already established a comprehensive legal body to regulate this domain. The primary legislative instrument governing the nation aviation sector is Law Number 1 of 2009 concerning aviation, which serves as the overarching statutory framework for air transportation safety, security, and sustainability within Indonesia jurisdiction. This critical piece of legislation dictates the standard and practices required of all stakeholders in the national civil aviation industry, aligning domestic. Ladies and gentlemen, operation with recognition international norm and safety protocol. Furthermore, the enactment of Law Number 21 of 2025 concerning airspace management. Milestone in Indonesia legislative evolution, providing a robust legal architecture for the strategic and synchronized utilization of the nation's vertical territory. The statute yields profound benefits by institutionalizing an unified command and control mechanism that harmonizes the dual imperative of civil aviation and national defense. The future of air law theme is chosen to bridge the gap between current regulation and future technological realities. Key challenger, the first regulation that responsive to the development of the integration of unmanned aircraft system, urban air mobility, and high-tech aircraft. Second, harmonization of domestic regulation with international standard, IQ, UNCLOS, and airspace agreement. And third, strengthening national institution capacity for air law enforcement, improving human resources quality, and strengthening legal infrastructure. Opportunities. The first, establishing a framework that encourages innovation while maintaining safety and accountability. Second, increasing public-private partnership to accelerate the adoption of new technology. And third, establishing Indonesia as global class regional hub through transparent and inclusive law government. International perspective, air law and outer space law. International air law is rooted in aviation safety, interoperability, and navigational access between states. Outer space law emphasizes state responsibility, equitable utilization of benefit, and the principle of peaceful usage, the role of IQ and multilateral framework. IQ serves as pillar of global aviation safety and operation standardization. And the space legal framework is involving through document on state responsibility, protection of the space environment, and governance of the commercial activities. The key trends, integration of air law and outer space law through issues such as cybersecurity, privacy, and environmental protection. Technology innovation in high-tech aircraft, unmanned aircraft system, urban air mobility, and microsatellites require new regulation that guarantee operational freedom while upholding international accountability. Regional and multilateral cooperation to establish dynamic yet stable norms. Progressive yet stable regulatory policies, utilizing data for policy evaluation, accelerating the licensing process without compromising safety standard, and improving reporting mechanism and cross-agency coordination. National capacity building, the strengthening aviation regulatory agency, increasing training for judges and law enforcement officers on air and space issue, and strengthening air law academies to produce human resources ready to face future challenges. International cooperation, active participant in IQ meeting, space law forum, and the formation of regional alliance to share best practice, technology, and resources. Responsible innovation, developing regulatory framework for drones, urban air mobility, and space exploration with the focus on safety, privacy, and environmental protection. Added value for Indonesia, becoming a competent, inclusive, and adaptive air law hub for technology advancement. Encouraging the adoption of international standards that align with the national context, culture, and public interest. And now by saying Bismillahirrahmanirrahim, international webinar, Faculty of Law Unsurya, with the theme The Future of Law. I say that the future of air law Indonesian and international perspective on air, the space law formally open.
Thank you, Mr. Rector. Our sincere thanks to the Rector for the opening speech and the highly insightful material shared during this webinar. Now, at this time, we would like to invite the Rector to present the symbolic e-certificates to our distinguished speakers. We kindly request all speakers to please turn on your cameras for this moment.
The first, okay, thank you, Dr. Rizky. The first symbolically, I would like to present this certificate of appreciation to our distinguished guest speaker, Dr. Jinyoung Choi. Thank you for supporting the development of the Faculty of Law Unsurya. We wish you the best of health always.
Thank you very much for the certificate. It's my honor.
And second, symbolically, I would like to present this certificate of appreciation to our distinguished speaker, Ridha Aditya, LL.M. Thank you for supporting the development of the Faculty of Law Unsurya. We wish you the best of health always.
Thank you.
And third, symbolically, I would like to present this a certificate of appreciation to our distinguished speaker, Dr. C.Fr.A. Thank you for supporting the development of the Faculty of Law Unsurya. We wish you the best of health always. Thank you.
Izin masih mute, Pak.
Suaranya ke-mute, Pak Rizky.
Masih
Okay, I will say again. Thank you, Mr. Rector. Thank you very much for the symbolic presentation. we have now reached the core of today's event. To lead our upcoming discussion, I would like to hand over the Zoom to our moderator for this afternoon. Our moderator, Mr. Henry, he is one of students from Master of Laws Unsurya. Mr. Henry is distinguished alumnus of California State University, right? And Mr.
Yes.
Henry, the Zoom is yours.
Okay. Thank you very much, Mr. Rizky. And for now, before we begin our thoughts, may we kindly remind all participants to mute your microphones and switch off your cameras. We also ask everyone to hold all questions until the end of the presentations during our Q&A sessions. Thank you very much for your cooperations. And our next agenda is to welcome our first speaker, Dr. Supriyabu, a distinguished lecturer from Master of Law program at Universitas Dirgantara Marsekal Suryadharma. Please join me in welcoming Dr. Supriyabu. You may take the floor, Ms. Dr. Supri.
Okay, thank you very much, moderator.
Of course.
Henry. May I start now?
Yes, you may
Okay.
start now.
Would you please show my presentation, Mr. Rizky? Okay, Honorable Rector of Unsurya, Air Vice Marshal, retired Dr. Sungkono, S.A. M.Si, Honorable Dean of the Faculty of Law, Air Vice Marshal, retired Dr. Sujono, their university all officials, my colleagues, Ridha Aditya Nugraha, LL.M, Air and Space Law Studies, Prasetiya Mulya University, Indonesia. Here, Dr. Jinyoung Choi, Air and Space Law Studies from Leiden University. All students and all seminar participants. Assalamualaikum warahmatullahi wabarakatuh. Okay, based on Rector's statement on the background at the opening of our webinar, that one of the factors that civilian aviation safety I raised in this seminar is the enactment of the 1982 Law of the Sea for Indonesia as an archipelagic state, also has effect on the implementation of air traffic regulation, especially with the enactment of the Indonesian archipelagic sea lanes also. Indonesia, there are two important problems related to the use of airspace. One, namely the implementation of Article 5 of the 1944 Chicago Convention on the right of passage, and related to the implementation of the right of way in Indonesian archipelago as consequences of the enactment of the 1982 Law of the Sea, which has an impact of aviation safety issues. Next slide. Next slide, please. Next slide, please. Okay, next. Okay. The 1944 Chicago Convention in Article 1 formulates that the contracting states recognize that each state has complete and exclusive sovereignty of the airspace above its territory, which means that every country recognizes the existence of full and exclusive sovereignty for its country. But talking about territory, state in Article 2, next slide please, stated that for purposes of this convention, the territory of state shall be deemed to be the land areas and territorial waters only, adjacent thereto under the sovereignty, society, protection or mandate of such state. This concept, there is no recognition as archipelagic state. The distinction is very clear that there is no sovereignty over the high seas and the terra nullius, of course. In this case, the territory recognized by the new international law and international customs of the land, the territorial sea and the high seas. There has been, although the United Nations, no agreement on the upper limits of airspace and outer space. Committee on the Fiscal Uses of Outer Space, we call it INCOPOS, has included this agenda at every season since 1967. Indonesia itself has unilaterally set a limit of 110 kilometers above sea level, stated in Article 6, Paragraph 2 of Law Number 21 of 2025 concerning airspace management. Next, please. We can see in Article 3 of the 1944 Chicago Convention explained. It is clear, no state aircraft of contracting state shall fly over the territory of another state or land thereon without authorization by special agreement or otherwise. In accordance with the terms thereof, the contracting state undertakes, when issuing regulation for their state aircraft, that they will have due regard, I say again, that they will have due regard for the safety of aviation civil aircraft. Next slide. Article 5 of the 1944 Chicago Convention stated also its contracting state agrees that all aircraft of the other contracting state, being aircraft not engaged in scheduled international air services, shall have the right, subject to the observance of the terms of this convention, to make flight into or in transit non-stop across its territory and to make stop for non-traffic purposes without the necessity of obtaining prior permission, and the subject to the right of the state flown over the required landing. Each contracting state nevertheless reserves the right, for reason of safety of flight, to acquire aircraft desiring to proceed over regions which are inaccessible for without adequate air navigation facilities, to follow prescribed routes or to obtain special permission for such flight. Interpretation of this article is varies. Continue, for slide. Scholar Professor Pratna and Kislov opinion say that superintendent in airspace, which provide evidence that juridically the content of the article is not clear, especially regarding the meaning complete and exclusive territory and airspace. Bicheng also interpretation Article 1 and 2 state that the 1944 Chicago Convention does not define the terminology of airspace. To determine Rwanda's sovereignty over airspace, stated that there are three elements must be resolved: the use of airspace, the nature of its position, and the nature of its control to the exclusion of others. A more advanced view is the view of Ian Brownlee, explaining that the terminology of sovereignty is synonymous with independence state. Continue. How about state practices? In the implementation of Article 5, mentioned above, there are many problems, namely when aircraft flying over the territory of other countries must have prior permission. To require aircraft desiring to proceed over regions which are inaccessible or without adequate air navigation facilities to follow prescribed routes or obtain special permission for such flight. Countries' interpretation in this case vary. In this case, ICAO assumed that flight like this do not require prior permission. But this reason, the ICAO Secretary on the instruction of the ICAO Council conducted an analysis of this issue. As a result, since 1953, it was found that only 6 countries did not require prior permission, only needed notification, while the other 36 countries required prior permission, including the United States and United Kingdom. This issue still ongoing until now. Next slide. Problem fly over the Indonesian archipelago islands. This is the second problem. Fly through Indonesian airspace. As a consequences of being an archipelagic country, Indonesia determines the archipelagic islands on which can be used as a flight routes suitable for foreign ship and aircraft. In this case, Indonesia has established the Indonesian archipelagic sea land based on government regulation number 37 of 2002. The line designed by Indonesia because of Article 53 UN Clause 1982. The use airspace over the Indonesian archipelago sea land as an air route so that the law of the sea not only regulates matters relating to the provision of the sea, but also the provision of the air. In fact, the provision regarding international aviation are governed by several provisions such as the Convention on International Civil Aviation of 1944 and some annexes or additional provision of this convention. As for national aviation, it is regulated also based on law number 1 of 2009 concerning aviation and other provision regarding civil aviation safety. The article that regulates the sea land is contained in Article 53 UN Clause 82, United Nations Convention Law of the Sea. This article a compromise article at the time of discussion. Besides that, according to Professor Mukhtar Kusumaatmaja, expert law of the sea from Indonesia, because the law of the sea is also very comprehensive. According to Professor Martin Samani, expert from Australia University, said that many are caused by formulation of the article that not complete and clear. Professor R.T. Agus, expert from Pajajaran University, expert in sea law, his opinion is that the provision of Article 53 above are more of an option and not obligation for the archipelagic state to provide a stable land for continuous direct as fast trajectory as possible. Different opinion from the United States and Australia say that the sea lands should include all route normally traveled by international navigation before 1982. State practice. The implementation of the right to cross with the provision that normal flight are solely for continuous, direct, and rapid transit has also been interpreted differently by each country according to its national interests. As in the Bawean incident or case, on July 3, 2003, was two Indonesian Air Force F-16 intercepted 4 US Navy F-18 Hornet over island of Bawean. United States argued that flying the aircraft from the aircraft carrier was a purely normal. State in accordance with the provision of normal procedure for the purpose of surveillance of the aircraft carrier, and that passing through the Indonesian archipelago sea lanes, there was no obligation to ask permission from Indonesia and only had the obligation to monitor the frequency of communication without the obligation to communicate with air traffic controller. This opinion different from obligation each aircraft if fly in the air because they have to communicate with other aircraft or communicate with air traffic controller which rules in the air. On the other hand, some archipelagic countries such as Indonesia have their own interpretation of this meaning. In the Bawean incident or case, Indonesia stated that what the American planes did was violation of both 1982 law of the sea and also rules of the air. Next. Article of the 1944 Chicago Convention in Article 3. No state aircraft or contracting sets fly over the territory of another state or land there without authorization by a special agreement or otherwise. In accordance with the terms thereof, the contracting state undertakes when issuing regulation for their state aircraft that will have due regard for the safety of navigation of civil aircraft. Meanwhile, Article 12, which regulates the rules of the air or provision in the air, explained that each contracting state undertakes to adopt measures to ensure that every aircraft flying over the or maneuvering within its territory and that every aircraft carrying its national mark wherever such aircraft may be, for example, Hornet F-15 America, shall comply with the rules and relating to the flight and maneuver of aircraft there is in force. Of course, each contracting state undertakes to keep its own regulation in this is time to time under the convention. Respect uniform to the greatest possible extent with those established from time to time under this convention. Over the high seas, the rules in force shall be those established under this convention. Each contracting state undertakes to ensure the prosecution of all persons violating the regulation applicable. Also in Annex 2, Rules of the Air. In order, provisions such as in Annex 2 of the Rules of the Air, which are recommendation and standards related to the provision on how to conduct flight in the air, is mandated by Article 37 of 1944 Chicago Convention above. In this provision, several things are regulated, such as existence of flight plan, where it is required to include the selected route, which of course is a route recognized by ICAO, excluding the Indonesia Archipelagic Sea Route, as well as the obligation of two communication with air traffic regulators is regulated in section 3.6.3 of position report. With these provisions, air routes over the Indonesian archipelagic sea lanes cannot be an air route. I say again, cannot be an route option because they have not been recognized by ICAO.
Excuse me, Mr. Supri.
Yep.
Kindly note that you have 5 minutes remaining.
Okay. Law number 1 of 2009 stated that in case context of the implementation of sovereignty, the government carries out the authority to and responsibility of regulating airspace for the interests of national defense and security, aviation, and the national economy. This provision is the basis for the regulation of air routes issued by Indonesia government as a mandate by the Chicago Convention through Annex 11, Air Traffic Services, so that the determination of air routes, including over the Indonesian archipelago sea lanes, must also consider the country defense and security aspect. Other provisions are contained in Government Regulation number 4 of 2018 concerning the security of airspace of Republic Indonesia, especially in Article 19 to 22. Continue. Government Regulation number 4, 2018. Next. Foreign state aircraft may exercise, this is Article to compromise American aircraft, may exercise air passage right over the archipelagic sea land and or transit on the land that has been determined for the flight from one airport to airbase of foreign country. However, next please, there is still requirement, namely state representative of foreign state aircraft that exercise air passage right over the archipelagic sea lanes as referred to in paragraph 1 are obligated to notify the minister in charge of government affairs in the foreign field and commander of Indonesian national security. Thus must still have diplomatic clearance and security clearance. Next slide, please. Next. Yeah. Next. Recommendations. 1. Reformulating Article 2 of the 1944 Chicago Convention, especially Article 2 on state territory. The concept of archipelagic state must be present in the formulation of this article, Chicago Convention 1944. Number 2, reformulating Article 5 of the 1944 Chicago Convention gives civil aviation the right to non-scheduled flight over airspace or land for non-traffic purposes such as refueling or refueling without having to ask for permission, which is practice almost all countries require prior permission. Number 3, there should be cooperation between ICAO and United Nations Commission Peaceful Uses of Outer Space to determine the limitation and delimitation of airspace. Thank you very much. Give time to moderator.
Okay. Thank you very much, Dr. Supriya Bru, for the insightful and informative presentation. All right. Now, we move on to our second speaker. Ladies and gentlemen, it is now a great privilege to welcome our distinguished international speaker, She is from International Institute of Air and Space Law, Leiden University. Please welcome Dr. Jinyoung Choi.
Thank you very much for the kind introduction. Let me quickly share my slides. Could you tell me if you can see my screen with the entire slides?
Yes, we can see it.
Yeah, brilliant. Thank you very much for the moderator introducing me, and I thank you very much for inviting me on this international webinar on air law for Dr. Sungkono, Dr. Sujono, Dr. Bambang, and Dr. Rizky again. And I also thank you very much for speaking together with me for Dr. C.Fr.A and my dear friend Ridha. And last but not least, I thank you very much for attending this webinar for Civitas Academics. So today here I am to talk about aviation accidents and the law. So we all know about aviation law and we all know about aviation accidents and in theory what happens, but in reality it might also not always the same. It might not always be applicable when it comes to law in certain cases. So today I'll just really quickly discuss practical aspects of what happens when an accident occurs and how law applies. So when it happens to the accident, we normally think about safety only, but that's not always it. So what I really intended to discuss here is what we call paradigms. So when an accident happens, then we start doing the investigation, technical investigation that I call it. And there we're involving technical factors. A machine cannot work sometimes, and human factor, pilots, air traffic controllers, and anyone working in aviation might not function properly. And also sometimes it's the organization that is not working properly. So that is adding up to the safety. And these days we are now talking about total system of civil aviation, which means that actually the entire aviation is working as a system. So it's not only one factor that is really impacting a safety, but it's actually the chain of trail of all the factors that I just mentioned. So that is how I actually define safety paradigms. What we do not really recognize sometimes is transparency. And when it comes to transparency, we then talk about how media and how we as civilians or officials are understanding the accident. So we actually can see it later in my presentation with how media is presenting what is happening with the accident investigation and what has happened with the aftermath of the entire thing. And for instance, about liability concerns and also about criminal liability and prosecutions. And therefore, that what is really important is to understand transparency vertically and horizontally. So when it comes to vertical transparency, we talk about normally how government is functioning. And because we pay tax as civilians to the government, we are actually allowed to know what is happening and what is done by the transparency and then government. So if an accident investigation is actually done by the government authority, although it is independent from the government, we as, again, civilians are supposed to know a lot of things there. However, some of you already might be recognizing the factor of just culture, meaning that, let me quickly go to the next slide of it. An atmosphere of trust in which people are encouraged and even rewarded for providing essential safety-related information. So in aviation, we have this theory called just culture, that if it is not really horrible mistake or not done by negligence or gross negligence or any intended action, then you shouldn't really punish anyone. And that is actually to boost the transparency among the peers, which then I call horizontal transparency. So that is what is also happening in air criminalization and accident investigation. At the same time, in certain countries, just culture might not apply only directly, and it might also apply, but again, because aviation is so international, we do not always know about legal factors so thoroughly. And that is why we are bringing this factor and paradigm of legal certainty, that law really has to be very clear for everyone to understand what your action is causing. And once you're committing a crime or an action, then you understand about the punishment following. But again, in many cases, it's very difficult to understand. And however, for government, it's always there's positive obligation to make the legal factors really clear, and that is regulated under international law. So these three paradigms are actually governing criminalization or any matters when it comes to aviation accident. But has safety remained all the same the entire time? That is actually not true. So before the Chicago Convention regime, which is done before 1944, before Chicago Convention came into force only a little later, then that's what I call pre-Chicago regime. And back then, the reason that we were regulating safety was for ground and technical safety. And that was because, say that an accident back then, yeah, technical factors were playing really big role in accident. And once an aircraft is really flying over your territory, then and that might just be fine. But if a foreign aircraft that is not functioning properly, that might fall into your territory, then an accident happens, then the people on the ground would be harmed. Therefore, that is why technical safety was really the biggest concern in pre-Chicago regime and that time of the years. And then until from that moment, so from the beginning of 1944, so Chicago regime, until the end of 1990s, then people then started talking about accident prevention. So we need to prevent accident by doing what? Doing the technical investigation. So by the investigation and results, we learn and then we prevent the accident. So recurrent of the same accident, we just do not let it happen again. So that was a whole deal about safety until then. But until early 2000, then people started understanding accident investigation a little bit differently to talk about managing the risk. So we do not wait until accidents happen, but we manage the risk. So that is sort of the gauge of how an accident can happen and certain factors that is adding up to accident and causes, we are managing it. And since early 2010, people started talking about acceptable level of safety. So not letting accident happen at all is just impossible because it just happens somehow. Although you've done so many things so well, accidents still can happen just by accident, as the term also calls itself. So then ICAO and people started talking about, okay, then let's keep it safe, but to the level, and also risk and hazard can be there in place, but to the level that we can accept it. So people then started talking about, okay, then what is acceptable level of safety? What is acceptable? So that is actually the ongoing discussion in aviation law and aviation safety to determine how to organize these factors. But here you can see that how we are understanding aviation safety and possibly accident has been changing the entire time. So it's not really static status that we call, but it's really the dynamic mechanism that is developing throughout the entire time. Then, like I mentioned earlier, there's just culture. Just culture didn't really exist at the very beginning of safety paradigm or pre-Chicago Convention regime because it just came up as a factor in around early 90s and late 90s, people talking about, okay, accidents. For us to learn a lot of accidents and what has happened and why that has happened, for us, it's very important to understand why it has happened. And who knows the most about the accidents is actually people who are involved in the accidents. So an example, again, can be pilots or passengers and whoever that is involved. And in my own PhD research, I actually discussed about pilots. Why? Because pilots are actually in the center of the cockpit. They're always in the operation. So there is not a single time a pilot does not play a role in an accident, good or bad. So if you start punishing their actions for them by giving a statement to the investigation board if they survive, then they will be fearing the punishment and they'll not say so much about it. That is what has happened with just culture. So just culture, although our focus is always on just culture, many times I wouldn't say always anymore, but then as part of safety culture, which says that you should be informed about what is happening. You should be flexible from learning a lot of things. As a pilot, as a person working in aviation, you need to report properly about what has happened. And you need to learn from that. And also in the end, just culture. So if you're acting just, then you shouldn't be punished. So the entire movement wasn't really there at the very beginning of aviation, again, that I recall it. And when was it really getting the importance? That was when the Chernobyl accident, factory accident has happened back in the time. So that is why I have this little picture in between here. And so the difference that you can learn before just culture and after just culture is actually what you can read on the right side of my screen. So here you can see this is actually the direct extract from the accident investigation report from one of the accidents that happened. People say that it was the most terrible accident that happened in Tenerife. And it was KLM flight crashing with Pan Am airplane. And there, the accident investigation report from Spain was actually saying certain things. So at the very last stage, you can actually read the following. Now, how is it possible that pilot with the technical capacity and experience of Captain Veldhuizen van der Zouten, the person of the pilot, it is not allowed anymore, by the way, to mention the name of the pilot in the report, but back then it was possible, whose state of mind during the stopover at Tenerife seemed perfectly normal and correct, was able a few minutes later to commit a basic error in spite of all the warnings repeatedly addressed to him. So you can actually read the tone of the report. So an error is a fact. An error committed is a fact, but to call it basic error is a fact, or is it your understanding? So you can actually read that the tone of the accident report can also change after just culture and before just culture. Although we understand all these facts, but then again, it doesn't always work in practice. However, I just wanted to introduce you how law is changing, how just culture has been changing, and how investigation board has been understanding accident has changed throughout time. Then let us see the real cases I collected 2 accident cases from Indonesia to just explain what is happening in practice. So Lion Air JT610 accident that happened back in the time. So the fact, I think you must know the more about the fact than I do myself, so I won't repeat it myself. So you can actually see that this is the map on the left side is actually from Flight Radar 24. An accident report, investigation report, technical report was then presenting only later that yeah, it was a mixture of a lot of causes that was causing the accident itself. So it was not only one person to blame, of course, although at the beginning people were talking about how pilots might have not trained well. But later they found out that it was actually involving Boeing 737 MAX 8. So it was a trial of one accident. It was just really unfortunate that it happened. However, at the same time it has just happened. And on the right side of the screen, you can see the extract of what I found on Google. So when I found Lion Air JT610 crash, then you can actually see a lot of media posts. Again, not accident investigation board report, but these results, which is saying that Boeing 737 MAX 8, which airlines use the plane and is it safe? Is it really in line with just culture approach? Not necessarily always. And Boeing ordered to pay a certain amount to widower of Ethiopian aircraft. So this is not really about Lion Air, but still you can see the tone of the accident report or the media footage as well. And you can also see that it's not fair. Indonesia's Lion Air crash families decree Boeing 737 MAX deal and with very emotional pictures. So we need to really understand, although transparency is really important, this is not always necessarily connected to just culture, but this is how reality is happening. And here in the middle, Le Monde article, if you see that about the Boeing order to pay a certain amount to the widower of an accident, then again, which evidence can you use? Can you actually use technical report? Not always. But is it always the same in all different countries? That's also not true. In certain countries, you cannot really use the accident report as an evidence. In certain cases, you can. And yeah, which law do we follow? So that's really an example of showing the complexity of aviation accident and all the proceedings that is following, and also about the fact finding. And then all these things are really making the law very difficult to understand. Hence, then we are connecting this to legal certainty. And another example is Garuda Indonesia Flight 200. So you again know the most about these factors, and I in particular leave this here because again, then you can see what is happening on Google and what is happening in the investigation board report, and also what is happening on media footage again. So on the right side of the corner, you can see the very, again, emotional and possibly hampering picture for safety that people are running around from the accident. And where did I get it from? I got it from one of the aviation blog who was writing about the entire accident. But is it really necessary for the fact finding? Not always. The one below is also what I found out from the media footage from Australia. So which is less emotional, but still really striking. And on the left side of the corner of the entire footage, then you can read Garuda pilot charged with deliberately causing crash. Also very tricky because again, deliberately is a very big word for you to use because that means you have an intention towards something. But how do we define intention is always the big question in criminal law. So whatever that is understood under certain jurisdiction might not be the same in the other jurisdiction. But still, quoting the court report with the quotation marks is not necessarily always delivering the correct information. But again, yeah, it's just really difficult. And then the second picture on the left side is the captain that ignored all warnings. Again, is it really about the fact finding or is it from YouTube? Or do you really want to get all the media footage of it or the attention from people. So it is really tricky. And then in the middle, which is the highlight of this view actually, is how a report was presenting the actions of the pilots. So it's the final report of Garuda Indonesia Flight 200 accident. So the investigation determined that the flight crew's compliance with procedure was not at the level to ensure the safe operation of aircraft. His attention was fixated, sorry, or channelized on landing the aircraft on the runway. He either did not hear or disregarded the GPWS alerts and warnings and calls from the co-pilot to go around. The co-pilot did not follow company procedure. And the last one, the Yogyakarta Airport Rescue and Firefighting Service vehicle were unable to reach the accident site, and some did not have appropriate fire suppressant. The delay and the lack of appropriate fire suppressant agent may have significantly reduced survivability. And then it's going on and on and on. And this is actually extract from the synopsis of the accident from the report itself. So then the question really goes to whether the court in any countries could actually make use of this report. If so, this would really play as a very strong evidence, but at the same time, it might not be admissible. And then also adding all these very particular tone of language, is it really safety oriented or is it not? I'm not trying to give any answer here. However, this is for us in aviation very important to understand that these discrepancies between paradigms and these tons of accident investigation report and also media footage are actually hampering safety. And we kind of need to reconsider the entire deal about the balance of paradigms. Then the question goes to again, is there one particular paradigm, which namely safety, transparency, and legal certainty? Is there anything that is dominant, or should anything be dominant? That's a big question remaining. So with that in the complexity, again, just culture never stood alone because you saw all the paradigms, and safety never stands alone either, as an example. And safety went through all the evolution, meaning that what's understood now correctly might not be correct in the future. So safety evolves and just culture and our understanding also evolves. And did he always support just culture? No, that is not the case because pre-Chicago Convention back then actually punishment actually was a tool to prevent the accidents, but which is not the case anymore. And we also saw the cases of Lion Air JT610 and Garuda Indonesian Flight 200 that these particular paradigms are actually really visible in any single cases with the examples of Indonesia. However, in the end, responsibilities in preventing accidents or managing risks or keeping the safety level acceptable is all on us. It's not necessarily in one party, but there's ICAO's effort to be made. States have to correctly regulate the entire thing. Organizations such as corporate or air traffic services providers should really work towards safety as well, and individuals, including pilots or us passengers, and some of you are already pilots, I guess, and air traffic controllers. So individual effort is also very important. And with that, if you would like to know more details, then my book recently has been published on which you can find on Clover. So I just posted a little picture so that you can see the title of it. And with that, I'd like to thank you very much for listening to my presentation. And any question can be addressed at the end of the session, and then you can send me an email. Thank you very much.
Yeah, thank you very much, Dr. Choi, for such an excellent and enlightening presentation. Okay. Now, last but not least, ladies and gentlemen, representing Air and Space Law Studies from Universitas Prasetiya Mulya, we are honored to have Mr. Ridha Aditya Nugraha.
Hello.
Please join me in welcoming him. Okay.
Thank you very much, moderator, for your kind introduction. Allow me to share my presentation. Let me know if you could see my slide.
We can see it.
Okay, thank you very much. So, good afternoon, selamat siang, Bapak Rektor, Bapak Dekan, Pak Bambang, dan juga Pak Rizky, and also my fellow speakers, Dr. Supriyabu and my dear friend Jin, and also Civitas Academica from Universitas Dharma. So I would like to bring the idea of having a situational awareness in this country. And I would like to mention what happened and what should we think in this year. So I will use the title Recent Developments on Public Air Law, the Indonesian Perspective in 2026. So again, thank you very much for inviting me to Universitas Dharma to share my research and also knowledge on air law issues. So we have two states of play in April 2026. So we're going to jump a little bit from one topic to another. The first one is about the harga tiket mahal or skyrocketing ticket price. So this issue brings us again the question on Indonesia's commitment towards open skies. Yes, it is being tested again this year, and domestic connectivity issues become the driving force because we just had the Eid al-Mubarak or Idul Fitri, and people are complaining about the high ticket price. Why could not we pursue a lower or a more affordable domestic ticket price? That's number one issue. And the second one is that just recently or a few months ago, in December 2025, Indonesia just enacted the National Airspace Management Law. So it means that at the same time, there are two laws on aviation. One is the Aviation Law of 2009, sponsored by the Ministry of Transportation. And then the National Airspace Management Law is sponsored by Ministry of Defense and the Indonesian Air Force. So let's take a look whether there are conflicting issues or they are encouraging each other. The first issue is about the domestic connectivity issues. So currently, the domestic connectivity shows that protectionism regime. It still lives in Indonesia, and Indonesia is among one of the few countries in ASEAN and also Asia who still conduct or execute the idea of determining the ceiling price or tarif batas atas, as we know, in bahasa Indonesia, and also the floor price, the tarif batas bawah. So before we go to the story, there are some mindset in the past saying that, hey, how could an airline sell tickets so low? Does the airline compromise the safety issue, or it's just a new business model? So based on that thought, Indonesia also encouraged the implementation of tarif batas bawah, or the floor price. A week ago, the Indonesian National Air Carrier Association had a meeting with the government, and they're saying that, look, we have a Middle East conflict, we have the Hormuz Strait crisis, and the oil are not coming. So there will be an increased price of aviation fuel of after. But could we, as airline, adapt and increase the ticket price as well? Because if not, then it will be a real problem, at least from business sustainability, which I could say that there's a potential which could encourage or perhaps affect the aviation safety. Now, if we take a look clearly at the situation, the last price and ceiling floor concept was introduced back in 2019. At the time, 1 liter of aviation fuel cost around $8,000 US. Sorry, 8,000 Indonesian rupiah. Now, just a month ago, it was almost double, almost reaching 14,000 Indonesian rupiah per liter. And now the new price at Soekarno-Hatta, it's almost 24,000 Indonesian rupiah per liter. We also need to see that there has been depreciation of Indonesian rupiah to US dollar. Back in 2019, it's not $1 equal to almost 70,000 rupiah, but I think it's slightly less to in between 12,500 to 14,500. So no wonder with this depreciation and the increasing aviation fuel price, INACA demands an increase of 15% for both. So the idea is that if this policy is accepted and perhaps the airline really needs it, then there will be an increase of 15%, additional 15% from ceiling price and also the fuel surcharge. What we need to see is from the academic point of view and also how we read policy and regulation is that Indonesia has said that, yes, we will develop open skies implementation because it's good. And so what does an open skies constitute? One of them is that there is no restriction of ticket price. So an airline could sell the ticket price as high as it's want or as low as the airlines wants it. If no buyer, then that's a business decision. But first, it must be clear that safety is not compromised. Maintenance, repair, and overhaul just as it is, according to the schedule. In ASEAN, we could see it. Why a flight from Jakarta to Kuala Lumpur or Jakarta to Bangkok could be far cheaper than a flight between points in Java Island, or perhaps points in Java Island to Sumatra or Kalimantan or Borneo, which is less distance than going to Kuala Lumpur or even Bangkok, Thailand. So we see it now. Now, for international flights or connectivity, there's already a consensus going on in ASEAN that the open skies, the no restrictions of price ticket happens. And you could see that perhaps going from Banda Aceh or Medan to Jakarta via Kuala Lumpur or Singapore is far cheaper than taking a direct flight in some cases. But the thing is that there's always a good side of the policy. If we maintain the ceiling price, we need also to mention those civil servants or businessmen who are doing business within this archipelagic. We could not travel by sea because it takes time. The only thing is that to travel by air. If we don't have the ceiling price and we want to fly tomorrow or the day after, in a normal situation, the price could be 5 times higher than the normal one. So if we cap the ceiling price, it's also good. It's also a safeguard so that the government spending won't be too much on the air transportation. However, it always brings pros and cons, and that's a policy. It's always, they have the two edges at the same sword. And nowadays, people are yelling, yes, but we also need to understand that airlines are yelling. Why? Because of the situation that mentioned earlier. Now, what are the benefits for the stakeholders? Let's say if we implement the open skies, or at least we increase the ceiling price and also the fuel surcharge. Perhaps many doesn't know that, let's say, airlines have debt either to airport, to the air navigation service provider, as well as the MRO, and perhaps to Pertamina as well. So they need to keep flying. The maintenance must be conducted on time. They need to buy the fuel, but is this a promise, or I would say, is it a debt, or they could pay it cash? They also need to have their own cash waterfall system. So I would like to say that it's about the cash flow and it's about the liquidity. So let's think about this issue, and I believe that students from Universitas Surya Dharma who learn about aviation law, it's a fascinating topic to be addressed and to be researched to help the government to find a solution. The second one, we jump to a more public one and to more defense policy one, is about the Air Navigation Zone Plan, Air Defense Identification Zone Plan, or the ADIS plan. So back in 2013, Indonesia once announced the Ministry of Defense and the Indonesian Air Force that perhaps the best ADIS is that if the coordinates is equal to the furthest point within the Indonesian exclusive economic zone. But at the time, there was discussion and perhaps polemic between the Ministry of Defense, Indonesian Air Force, and also Ministry of Foreign Affairs on how they see the exclusive economic zone. And at the time, we need to understand that the flight information region, especially around Singapore and Natuna, is still at the Singapore hands, not the Indonesian hands. The rule is simple. You could enact ADIS if you have control. And if it is needed to have a control, then it means that you need to gain, or you need to control the FIR. The status quo changed in 2022 when the Indonesian and Singapore realignment agreements comes through. Many areas, especially close to Natuna, are now in Indonesian hands. So theoretically, Indonesia could implement ADIS there. And then 3 years later, Indonesia enacted law on national airspace management. And within the law, if you see one of the provision, it mentioned about ADIS, and it mentioned about the obligation to draft and implement an implementing regulation, which means a peraturan pemerintah or a government regulation 1 year after the law was enacted. So it means that there's a deadline until December 2026 to have that implementing regulation. The question will be how to draft the ADIS. Legally speaking, there is no provision on ADIS at the Chicago Convention, the Magna Carta of Air Law. And second one, ADIS is not a customary international law. So ADIS is best practice. The question will be, is there any parallel effort that needs to be taken? For example, does Indonesia should ratify the Article 3B Convention prior enacting ADIS? This is one of the most important question, I think, that need to be think at the same time, because this article encourage also protect that civil flight from being or perhaps there will be a situation that will endangers the flight. So I think there are some voices that not being unmute. So thank you, moderator. So, yeah, the question will be, should Indonesia ratify Article 3 bis of the Chicago Convention? Because this article is important to avoid any threat to civilian flights. There must be no use of weapon, but the polemic of the definition of there must be no use of weapon, it also need to be seen by case to case, whether this is in peacetime or wartime. Well, of course, both say that civilians' flight must not be endangered, but what will happen if the civilian flight is already determined, or perhaps it could be already decided that the aircraft shall be as unfortunate as the 9/11 ones. So the real threat is there. Could the military still take down of the aircraft? And the question will be, should it be a manned fighter aircraft or an unmanned UAV? Because it also make a difference when there will be such a, let's say, consequences like serious consequence like this. So let's take a look at the picture first. Since ADIS is a best practice, then overlapping ADIS is totally fine. You have an overlapping ADIS above Japan, South Korea, China, and Taiwan. However, civilian flight, especially the scheduled one, they are still flying securely. There is no threat towards them. Why? Because all of them, I believe that we need to check whether all of them have ratified the Article 3 bis of the Chicago Convention or not, but at least they have a commitment towards it. So within the overlapping ADIS, if there's an issue, it will be much more on the state aircraft rather than the civil flight or the civil aircraft. And in terms of ADIS, who will be the threat for Indonesia? I think Southeast Asia is a region of peace. Of course, we need to reduce tensions, unnecessary tensions with other states as well. However, could it be a civilian activities that raise up the importance of having an ADIS like this? If you could see it, it's a balloon or a Google balloon that back in the year of 2023, there's a Chinese meteorological balloon flying over Canada to the US. It flew that high, and there are some sightings. Well, at the end, the US Air Force decided to shoot down of it. It happened within the sovereignty, not before they're coming within the territory, but still, it's also a best practice to be as a lesson learned from Indonesia when they want to enact ADIS next in 2026. The most, or another example which I believe important is that the Korean airline flight, the unfortunate one in 1983, that at the time we need to bear in mind that there are technological difference. At the time, radar, etc., when they're entering the false or the wrong number or points, there could be a shifting from the intended path with the actual path. And at the time, Korean airline flight 007 flew over the Soviet Union. And close to Sakhalin Island, there are military infrastructure. And from the USSR perspective, now Russia, because they're not responding, then at the end, they decided to shoot it down. Lessons learned that if they know that it is or it was a civilian flight, that there won't be a shutdown towards it. However, how to determine that within the night? So there are some best practice that sometimes when our aircraft are flying above conflict zones, the cabin crew asked us to open the window to let the stakeholders nearby know that it's a civilian aircraft. So that's a thing that developed from time to time. But again, it's Article 3 base who decided the fate that there shouldn't be any repeated cases like the Korean Airlines Flight 007 anymore. So the M8 as well, it should not be shut down. And enacting this means that the Indonesian Air Force need to know and to obey this such kind of norm. The pilot fighters, perhaps most of them don't learn law. They need to learn and know law better on these things. Humanitarian law, yes, Article 3 base of the Chicago Convention, etc., to avoid unfortunate things happening. So it reached us to the final stage of presentation and also conclusion. If Indonesia wants to draw ADIS, where to draw? If you take a look at the picture here, the dark blue means the sovereign territorial waters. Pak Supriyabu has mentioned about this as well in Annex 2, in Article 2 of the Chicago Convention as well. The light blue is the claimed exclusive economic zone of Indonesia. Seeing from the Middle East conflict, a success of an invasion relies on air sovereignty. A success on invasion relies on how they could break the air defense. So the question will be, if Indonesia wants to enact ADIS above the territorial waters, which means 12 miles from the land, is it enough to prevent any attacks? However, do we also need to expand to 200 miles in some of the cases for the exclusive economic zone, mentioning that the neighbor is the threat? The idea is that globally, we need to reduce tensions to reduce war, to reduce the chances of war. While in the northern part of Natuna, we have the dispute on exclusive economic zone, not the sovereignty, including with the China 9-dash line. So how should the Indonesian Air Force or the Ministry of Defense draw, plan, and enact its ADIS? It's also a remarkable topic for perhaps Universitas Surya Dharma students to write a thesis on it. Because we need more thinkers and we need to review more norms before enacting or drawing the new ADIS plan. So with this, I would like to conclude my presentation. So thank you very much for your kind attention. Back to the moderator.
Okay. Thank you very much, Mr. Ridha, for sharing your valuable knowledge and perspective. Now, distinguished guests, ladies and gentlemen, we now arrive at the question and answer session. Before we begin, allow me to briefly explain the guidelines for this session. To ensure smooth and effective discussion, first, please introduce yourself briefly before asking your questions. Second, kindly keep your questions concise and relevant to the topic. You may either unmute your microphone or submit your question through Zoom chat. And third, we encourage one question per participant to allow equal opportunity for others. You're welcome to direct your questions to specific speakers or to the panel as a whole. Thank you for your kind cooperation. Without further ado, I would like to open the floor for questions. Please raise your hand if you would like to ask a question. Wow.
We must have been very, very clear in our talk.
Yes.
Okay. Thank you very much indeed. Sorry. Can I have a question, please?
Yes, Mr. Prasetya Halim.
Okay. Thank you very much for the occasion given to me. My name is Prasetiya Halim. I'm a student of Magister Law in Surya Dharma University. I have a question to Mrs. Jinyoung Choi from Leiden University. I will direct to the question about according to Jinyoung Choi views in the presentation. I just want to know about because she gave the example about the Garuda and also Lion accident. So from Jinyoung Choi views, what is the fair boundary between an honest mistake did by pilot and a criminal offense when the pilot is involved in a plane crash? That's the direct question for me. Thank you.
Thank you very much for your question. Unfortunately, I don't have an answer for that because that was the whole deal about actually just culture. What law understands, what the courts would understand about the negligence or intended action would be very different per another court to begin with. And then for you to understand what it actually means as a pilot, say, as an example, that will also be very, very different. However, what I also wanted to discuss here, now I didn't do that today, but in the entire topic is actually the training when it comes to pilots, at least, or for any other personnel in aviation. The training is very internationalized and it's very standardized. So many cases, although there might be here and there very little sweet peaks and in there, most pilots do have collective view towards their own actions. So they understood what action should have been committed and what action shouldn't have been committed. So I think that could be actually good boundary for us to set up to say what is intentional and what is not intentional. However, from my own perspective, that is all I can give. By theory, I can say that they have the common view. But again, what is perceived correct in my own view is also not considered correct in your jurisdiction and any other jurisdiction. But again, collectively, pilots do have a view which might again differ from the views of the other practitioners in aviation. So that is just my answer.
Thank you very much.
Moderator,
Yeah.
I may ask. So I'm not a pilot, but Dr. Supriya, who is a pilot? Perhaps Pak Supri has a view on that. Because Pak Supri is flying military aircraft and civil aircraft, so I believe he also could provide a very good insight, if I may comment.
That's a very good point, Dr. Supri. Do you have any feedback on that?
Please.
Your mic is muted, Dr. Supri.
Unmute ya.
It's your mic still muted, Dr. Supri.
Oh, sorry. Also no answer for this question because based on result of KNKT accident investigation that the case also through the but the pilot, especially in Garuda in Yogyakarta, pilot is not charged for this accident, even in the first. Karena ini yang bertanya orang Indonesia, saya jawab aja ya. Jadi kalau di pengadilan pertama memang disalahkan, tetapi setelah dia banding itu pilotnya tidak disalahkan. Ya, memang karena hasil dari KNKT itu hanya tidak untuk menyalahkan orang, tetapi hanya how to memperbaiki lah yang selanjutnya. Ya. Jadi hanya itu. Dan memang kalau misalnya saya juga mengajar di Ermensif ya, masalah etik pilot ini sampai sekarang ini memang belum ada. Ya, saya juga tadi menunggu sebenarnya statement dari apa namanya uh, Jinyoung Choi uh, regarding pilot action, because there is no currently no applicable code of ethic for personal pilot. Maybe it is very important for next aviation law for put the code of conduct of pilot. Yeah. I think it's very important. Thank you.
Okay, so I'll help translate that to English. So I believe Dr. Supri says that after the appeal hearing, the Garuda pilot isn't convicted by law. So it's still accordance to what Dr. Jin Choi just said. Okay. Is there any further questions? Okay. We will welcome our next person to ask questions. Feel free to unmute your mic or use the Zoom chat. Okay. While waiting for more participants to think about more questions, maybe I'll ask some questions. So, for example, what's the legal challenges arise from the integration of unmanned aircraft systems into civil aerospace? Feel free for any speaker to open up and answer my questions.
So I think it's one of my presentation that I mentioned the UAV. So yeah, you have the UAV already within the Chicago Convention. Now, the issue is that let me link this with the Air Defense Identification Zone. The Indonesian Air Force and also other Air Force in the world could do interception. And the question will be, what will happen if the UAV is sent to intercept and there is a cyber attack or technical failure, which at the end, the UAV endangered the civil aircraft with civilian on board. So I think I would like to address that issue as well, because we're also living within the cyber attack era, right? We have the cyber law, we have the cyber attack, and sometimes just one little incident could trigger a war, like the World War I, the World War II, and also the recent regional conflict as well. I think that's my point of view. Thank you.
Thank you very much, Mr. Ridha. Okay. Feel free to open your mic or use the Zoom chat to ask questions.
Moderator,
Yeah.
ya, my opinion, UAV in Indonesia, ya, there is some regulation for use UAV Indonesia. One of them, transportation regulation number 63 2021, yeah, regulated we call it drone, but only below below 25 kilogram, yeah, or 25 kilogram, yeah, fly, for example, only for hobbies, yeah, hobbies, and for recreation, and then only fly below 400 feet in Indonesian control airspace. For the drone used for, we call it for transportation, it should be referred to IQ regulation, of course. But it is difficult to practice because how to, I already talking with my colleagues from Indonesian Air Force who operate the drone in Natuna. It said that to fly this aircraft before air traffic control issued a notem for them. Yeah, should be block airface first. Yeah, so all aircraft operating in this area can now there is drone operated in certain altitude. In Indonesia regulation right now for the drone. Thank you.
Yeah. Thank you very much, Dr. Supri, for the clarifications. Also stating the transportation regulation, I believe number 53 year 2021. So I'll look into that later. Thank you. Okay, now we can move on. There's questions in Zoom chat, and I'll read it for the speakers. So thank you to all the speakers. It's from Mr. Bayu Suwito. So nowadays, the war that are started by United States and Israeli country really make a big impact for the civil aviation safety, because the retaliation from Iran that got a lot impact from their attack from US and Israeli. The ravaging retaliation from Iran get through many airspace of couple nations in the regime areas that caused many airspace being disturbed by this war. The safety passengers of civil airplane get intervened because of this action. Now, how do international community make statement for this? Because war nowadays mostly at the airspace, not above the ground. Speakers, do you get that?
Should I perhaps add a few words on this? Not necessarily my topic, but what is very important is what we have been discussing in this webinar is actually about International Civil Aviation Organization. So in the big term, although civil aviation has been disturbed, it was impacted by the war situation, which is then going actually outside the capacity and scope of Chicago Convention. At the same time, what is again important is what Dr. C.Fr.A. was talking about, like in the sovereignty. So each sovereign state has its capacity by law to close its airspace. So for that, although, yeah, certain countries might close its airspace by its own regulation, they might not do it, but then that's where the sovereignty really plays a role. And there was not much, actually, there is not much for other states can do actually about these things as well. And yeah, indeed, war is mostly in the airspace. So from the civil personal point of view, there's not much that we can add, in my opinion. But it's also sometimes private air law plays a role that insurance companies would not necessarily give the permission to the airline to fly over a certain region of the world. So it's not necessarily, again, how the international community is reacting, but rather contractual development among parties. I hope I answered to the question in a broad sense.
So allow me to jump into Jin's answer. If we get back a decade ago that the MH incident, the tragic accident happened in Ukraine, there was a question why Ukraine closes the airspace only above 35,000 feet, but not the whole of it. So in other words, the state of Ukraine is also responsible on overseeing their unification service provider and ensuring flight security. That's a big lesson that afterwards, there is no more fragmented closure of airspace. Usually they just close. Of course, it's also a business because just my analysis, if let's say one state closed the airspace, will there be any guarantee that when they open it, airlines will fluidly through the gates? Because it's also an operation cost. So we need to think about that perspective. However, one thing is that, again, Jin has also mentioned about the insurance. The question now will be, with the skyrocketing oil and the need to ensure efficiency, the question will be, will an airline operator be scared more to ICAO or the insurance? That's also a big question, because sometimes not every airlines, usually they lease aircraft, and there are conditions that the owner say that, yeah, you can fly this route, but only if you're not going through this A, B, or C airspace, which means costly. So the question will be, who is more in charge now? That's also a rhetoric question, because we're talking about the business sustainability within these difficult times. And if we just saw news recently, like Cathay Pacific, they already double up their price ticket. And it's already announced within their website that now not everyone can fly. It also goes with other airlines. So I hope this perspective could also enlighten the question. Thank you.
Okay, thank you very much, Dr. Jinyoung Choi and Dr. Ridha for your answer. Is there any more questions? Feel free to ask the questions using Indonesian language and I'll help translate it. We still have a couple more minutes for the Q&A session. Let's call for anyone who want to ask questions. Okay, last call before I'll end the seminar for today. Thank you, Mr. Rizky.
Kelihatannya mungkin udah cukup.
Kelihatannya begitu. Seems like so. Hey, thank you very much, ladies and gentlemen. We now have reached the end of today's seminar. On behalf of the committee, I would like to express our sincere gratitude to all speakers and participants for your presence and contributions. We sincerely hope that today's seminar has been beneficial and enriching for everyone. And before we officially conclude, we would like to invite all speakers and participants to turn on their camera and join us for a group photo session. Ya, silahkan dibuka kameranya, kita ada sesi foto bareng. As a reminder for the agenda, after the photo session, we're going to have a closing remarks from the deacon. Okay. If you please, Mr. Rizky, for the group photos.
Okay, I will take a screenshot. Slide 1, 1, 2, and 3. Slide 2, 1, 2, and 3. And third slide, 1, 2, and 3. Next slide, fourth slide, 1, 2, and 3. And the last slide, 1, 2, and 3. And back to you, Mr. Henry. Okay, please, Mr. Henry. Still mute.
Oh, sorry about that. Okay, now before we end our webinar, I welcome it's my honor to invite the Dean of Faculty of Law. Please welcome Mr. Sujono for closing remarks.
Thank you, moderator, Mr. Henry. Good afternoon and greeting to us all. The Honorable Rector of Universitas Marsekal Surya Dharma, Vice Marshal Retired, Dr. Sungkono, our highly esteemed speakers for today, Dr. Jinyoung Choi, thank you, from the International Institute of Air and Space Law, Leiden University. Mr. Ridha Aditya Nugraha from Universitas Prasetiya Mulya, and Dr. C.Fr.A from Unsurya. As well as to all distinguished guests and webinar participants whom I am proud to have here. Allow me to introduce myself. I am Air Vice Marshal Dr. Sujono, Dean of the Faculty of Law, Universitas Dirgantara Marsekal Muda or Unsurya. The Faculty of Law encompasses two study program, the undergraduate program in law and the master's program in law. We are guided by an academic vision deeply characterized by airspace and aviation disciplines. Let us give thanks as we have reached the conclusion of this international webinar carrying the future of air law, Indonesian and international perspective on air and space law. The comprehensive presentation and the interactive 30 minutes question and answer session we just had were truly enlightening for us all. The Unitary State of the Republic of Indonesia is a participant in the 1944 Chicago Convention on International Civil Aviation and has also ratified the Treaty on Principles governing the activities of state in the exploration and use of our space, including the moon and other terrestrial bodies of January 1967. As a participating country in the Chicago Convention, Indonesia has regulated to airspace above its sovereign territory in accordance with Article 1 of the Chicago Convention, which determines that every state has complete and exclusive sovereignty over the airspace above its territory. In this regard, Indonesia has law number 1 of 2009 concerning aviation and law number 21 of 2025 concerning airspace management. Therefore, I welcome the term of the international webinar, The Future of Air Law, Indonesian Perspective on Air and Space Law, because it addresses an important and strategic issue at this time. I would like to express my deep gratitude to Dr. Choi from the International Institute of Air and Space Law, Leiden University. We are well aware that Leiden University process on the best and oldest law faculties in the world. From Dr. Choi, we have learned a great deal regarding legal protection and pilot liability and aviation accident from the perspective of international law. I sincerely hope this collaboration will continue. For administrative purpose, we kindly request Dr. Choi's willingness to provide us signature on the report that Dr. Rizky will send via email. My sincere thanks also go to Mr. Ridha from Universitas Prasetiya Mulya, who provided an excellent exposition on law number 21 of 2025 concerning airspace management. We recognize that this airspace management law offers numerous benefits. one of which is the comprehensive regulation of national airspace to ensure legal protection and national security. Mr. Ridha is close, always and generously support the advancement of the Faculty of Law Unsurya. Furthermore, I extend my appreciation to Dr. C.Fr.A for his presentation on air operation law. Dr. C.Fr.A is a distinguished lecturer in our Master of Law program and a former practitioner, having served as a pilot for both civil and state aircraft. Dr. C.Fr.A elaborated on the national and international regulatory frameworks governing aviation, navigation, and safety, and the execution of aircraft operation. The presentation discussed the future of air from both Indonesian and international perspective, highlighting how rapid aerospace advancement, such as private space exploration and the integration of unmanned aircraft system, are challenging current legal doctrines. A major focus in Indonesia's unique position as an archipelago state facing conflicting interpretation between the Chicago Convention and the 1982 law on the sea regarding airspace sovereignty and right of passage. Specifically, significant issue arise from the implementation of the Indonesian archipelago sea lands, where the right to cross flight often clash with national security interested and Indonesia's requirement for prior diplomatic and security clearance, as evidenced by dispute like the Bawean case. Finally, on behalf of the organizing committee, I apologize for any shortcoming or mistake during the event. I also wish to thank all the participants, both from which and outside Unsurya, who have remained online with us this afternoon. I warmly invite all participants to visit and consider furthering their studies at the Faculty of Law Unsurya. May you all always be blessed with good health. Thank you very much.
Thank you very much, Dr. Sujono. And as now it's the end of our webinar. On behalf of the organizing committee, I would like to express our sincere gratitude to our distinguished speakers, Dr. Jinyoung Choi, Dr. C.Fr.A, and Dr. Ridha Aditya, and thank you for sharing your valuable knowledge and insights. We would like to thank all participants as well for your active participations and enthusiasm throughout the session. We look forward to seeing you again in our future event. Thank you for your attention. Have a pleasant day. Terima kasih.
Thank you.
Terima kasih.
Thank you very much.
Thank you, Dr. Jim.
Thank you very much indeed.
Terima kasih.
You all.
Thank you, Mr. Ridha.
Terima kasih.
Terima kasih Pak Mas Henry. Terima kasih Pak Ridha, Pak Suryapto.
Pak Rizky, Pak Sujono.
Terima kasih semua. Assalamualaikum.